If I was Jeffrey Lawrence, you'd all be quiet and be listening to me. Ladies and gentlemen, Your Excellencies, distinguished judges, past, present, future, esteemed colleagues, dear friends. This is a panel on the making of the Rome Statute. The former German Chancellor, Otto von Bismarck, once said that if you love law and if you love sausages, you don't want to see how they're made. Well, I'm accompanied here on the platform by three of the most distinguished, experienced sausage makers in international criminal law. There are many people here who were at the Rome Conference and who will be, perhaps even in the discussion, complementing what they have to contribute to this discussion. Many others were not present, perhaps were too young to attend and have heard about it or read about it. It's perhaps nice for a minute just to think of those who were there and who contributed significantly, who are no longer with us. I won't try to give a full list. I think that would be too difficult, but my mind turns to people like Sharif Bassiouni, who passed away a year ago, to Hans-Peter Kaul, who headed the German delegation and was a member of the bureau, I think, at the conference, and left his fingerprints all over the Rome Statute in many respects. Christopher Hall of Amnesty International, who was one of the great writers who contributed writing in the American Journal of International Law after every session of the preparatory committee. Håkan Freeman of the Swedish delegation. I could go on. Medard Rolamira, who went on then to work at the International Criminal Court. Otto Trifterer, who was who made the main scholarly contribution when the conference was over. Kofi Annan, who presided at the final signing ceremony of the court. And I guess we could go on. The three who were here on the panel with me, I can remember vividly on that final dramatic day. I could remember each one of them, the contributions they made on that, the 17th of July. I think it was only later in the day that I saw President Judge Kirsch, Philippe Kirsch. He had been working behind the scenes for several days crafting this mysterious package that we were long awaiting, and it was finally circulated the morning of the 17th, and then had to explain it, and above all, make it understandable to the people at the conference, both those who could vote and those who were not going to be voting, that there were no more modifications, that this was not a document that was up for negotiation, that it was take it or leave it. And I was always amazed at the skill and the insight and the talent of the people who crafted that package and the confidence, or perhaps lack of it. I'd love to hear some reflection on what the odds were, because it was not at all certain that that package was going to be acceptable on the morning of the 17th of July, and I wonder if we could even put a percentage on it. What was the likelihood of it? The first person I saw that morning who's here on the panel was Bill Pace, because Bill and I were in the NGO room, and Bill was, of course, presiding over the NGO coalition. I say presiding, it was a bit like herding cats to be at the top of the NGO coalition, and it was very helpful to the NGO coalition to have a more senior, avuncular person like Bill Pace, who could try to, and it was a difficult, unruly crowd the morning of the 17th, because NGOs are notoriously have tunnel vision and have their own agendas, and they're looking for that, and they're not really, they don't always have a picture of the whole. And Bill will remember we sat there and read it for about 2 hours, and they were like children who had got almost everything they wanted for Christmas, but they didn't like the color of the present, or they were missing the batteries or something like that. And then later in the day, of course, we went through these dramatic sessions, first of the Committee of the Whole, which was presided over by Philippe Kirsch, and where there were some very crafty somewhat elegant diplomatic maneuvers to get the package through at that stage. Then we moved up to the big room where we had not really been at all during the Rome conference, and it was a bit mysterious, and there were buttons to press instead of hands to raise about the vote. And then it was no longer Philippe Kirsch who was presiding, but it was Giovanni Conso, the Italian, I guess he was the foreign minister at the time, and Conso called it to order. And then immediately David Sheffer, the American head of delegation, took the floor and said, "We call for a vote." And I thought everybody held their breath and gasped. And then I remember seeing people saying, "No, wait a minute, not so fast." And they were up there, and there was Hans Karel in the middle of the crowd with the people from the team of the UN Secretariat, Roy Lee and Manouche Asanjani and others. And it appeared they were trying to delay everything for a little while until everything got sorted and everybody took a deep breath and knew what was going to happen. And then we had this spectacular vote that initially wasn't obvious either exactly what the result was, because we had this strange board that showed the colored lights for yeses and nos and abstentions, and the nos and the abstentions were red and orange, and sometimes it was hard to tell the difference between them. And then we had to wait a few more seconds until we had the answers. Before turning to them, I'm just going to do a brief recapitulation of how it all began and how it got to the Rome conference. We've talked briefly earlier today about the General Assembly Resolution 95, which was adopted to recognize the principles of the Charter of the International Military Tribunal and of the judgment. And that resolution was followed immediately by another resolution, which is in a way more directly responsible for the International Criminal Court. That was the resolution on genocide, Resolution 96 of the first session of the General Assembly. And that resolution, at least the first draft, had been prepared by Raphael Lemkin. And Lemkin was, in a way, on the rebound from Nuremberg, because he had been here on the 1st of October, and there were reports of him talking to people in the lobby of the Grand Hotel. And he rushed back to New York, where the General Assembly was sitting in the second phase of its first session, and he proposed this draft resolution on genocide, which then was amended to include a proposal for a convention on genocide. And by the time the convention on genocide got to the General Assembly in a finished draft in 1948, it had a paragraph speaking about an international criminal court, and it was accompanied by a resolution mandating the Secretariat to proceed with preparations for a permanent international criminal court. And that work then went on for a few years until it came to a halt in the early 1950s, and it was not renewed until the 1990s, really. It was formally authorized in a General Assembly resolution of November 1989, but the work of the International Law Commission didn't actually start on it until the following year. There are still a few people around who were involved in the International Law Commission, although I don't think anybody in the room can claim that. Some of the names, I think there are 3 judges at the International Court of Justice, Patrick Robinson and Mohammed Bennouna, and of course James Crawford, who wrote the draft, piloted the draft that then was finally adopted by the International Law Commission and given to the General Assembly in 1994. I think Christian Tamushat was also on the International Law Commission at the time. And then it went to the General Assembly, and that process began, and there were people in the room who joined in at various stages along the way to the ad hoc committee. Fabrizio, were you at the ad hoc committee? I'm not sure, no. And then, we were, but there are probably people here who were at that. And then in the preparatory committee sessions, which began in 1996 and into 1997. And I don't think anybody still knew when that happened, whether we were going to get to a final result. And I think the tension was there really up till the last minute. It all seems obvious now, but it could have gone south, as they say. It could have gone pear-shaped, and we might never have had a result as well. So we're going to hear from our 3 specialists who all had different perspectives on it. I'm not going to introduce them in terms of their CV and their career, because this is adequately and very generously done by the documentation we've received. They're all well known to everybody in any case. Hans Karel, who was the senior legal officer at the United Nations, and who, of course, on the photographs of the final signing ceremony, you see him there, and he was involved, as I say, on the dais in when the final vote was taken at the Food and Agriculture Organization. Philippe Kirsch, who was a newcomer to the process in a way, because he had been engaged as a Canadian diplomat, as a senior international lawyer in the Canadian Foreign Service, and had been involved in chairing important important international lawmaking initiatives like the Ottawa Mines Treaty, and was called upon really in extremis at the last minute to step in when the man who had been designated to preside over the Committee of the Whole couldn't do it. And he had to quickly learn the ropes and to immerse himself in the details of the International Criminal Court in order to do that job. And then Bill Pace, who was presiding over the extraordinarily influential group of NGOs under the umbrella of the Coalition for the International Criminal Court. This is supposed to be an interactive session where the panelists will respond to questions and make comments, and then we will go to the audience. So we're not going to have 20-minute presentations by each one of the panelists, but rather contributions one by one on different issues. And I'm going to turn first to Hans Karel. And Hans, you were, of course, there at the conference. We all want to know what you think are the not only the contributions of the statute, but what are the issues that became defining issues in a way, and that with 20 years of hindsight now, you might have different insights into. You might see a little differently than you did 20 years ago.
Yeah. Thank you, Bill. It's great to be here, and I congratulate the Academy for organizing this Nuremberg Forum 2018. For me, it's interesting. We are three persons on the panel with William Schabers here. One representing the states, Bill Kirsch. One representing the NGOs, Bill Pace. And I representing the Secretariat. So my role was completely different from the other entities that were present in Rome. My responsibility was the organization of the conference. And of course, I'd been involved in setting up the criminal courts for Yugoslavia and Rwanda in the past, so I was familiar with the whole issue. But the Secretariat is different. This means that you're responsible for that states and others present can negotiate and produce a treaty. And here I must say that I was very concerned that the Secretariat should not be an element that could cause the conference to fail. So therefore I had prepared myself very intensely with my codification division in the United States Legal Office, with Roy Lee, as was mentioned here, who became the executive secretary of the conference, and Manoj Asanjani, who became the secretary of the Committee of the Whole that was chaired by Philip Kirsch. Now, for me also, it was a question of relations with the host country, because people must function in the state where you are. And I must say I had an excellent cooperation with the Italian authorities and also with the UN entity where we were in the building. So I thought that functioned very well. But this is something, a lesson that I drew, importance of having a good relation with the host country. And also another issue, namely translations. Maybe you hadn't thought of that. We had 700 documents during the conference, and those documents should be translated into the 6 United Nations official languages: Arabic, Chinese, English, French, Russian, and Spanish. How could we organize in Rome this? We couldn't. We had to communicate this to Geneva and to New York, where our colleagues in the translation departments assisted us. And these translations had to be produced immediately. So we got the documents in the afternoon, sent them away. In the morning they came back, and we could distribute them in the mailboxes, or as we called them in conferences, the pigeonholes, in the morning. So when the delegates came, yesterday's documents were there, translated into their languages. So this again is a lesson I learned, the importance of providing immediately translations for the conference. And then also, of course, contacts with one's superior. I informed Kofi Annan regularly on the standing of issues in the conference. And he was very, very interested in this. And I can tell you that also I thought that an important role was to act as a go-between between delegations if they wanted to convey discreetly a message from them to another delegation. And here I can tell you that there were occasions where the issue was such that I called Kofi Annan and said, maybe, Mr. Secretary General, a telephone call to this and that capital could serve the conference well. And I know that he was involved in that way. But here you have to be very careful, because basically it is for those who are present in Rome, the states parties and NGOs, to negotiate and to find solutions. But there were issues where the Secretary General can contribute. And of course, the major issues here that I identified was, of course, the need for the independence of the court. And I can tell you that my 10 years on the bench in my own country, I might say that I was brought up in the Swedish judiciary. Then I was rather suspicious about international criminal courts. But I completely changed my mind when I became a war crimes rapporteur in the former Yugoslavia. And I realized that nobody is going to do anything about the crimes committed here unless there is an international tribunal established. So this I had clear view about, and I thought that the independence was something extremely important that the states negotiated about. And then, of course, the exact role of the prosecutor. And here we heard Fatou Bensouda, and I cannot stress enough what is said about the responsibility of the states to cooperate with the tribunal, in particular the prosecutor. Also the victims, I understood, was an issue, and also the effectiveness of the court, but also a certain, shall we say, hesitation that the court should not be too effective vis-à-vis one's own country. And I mean, this is reflected later in the history of the court. Others might discuss that. And also the issue that came out that the prosecutor should have to go to the pre-trial chamber to receive a permission to start an investigation. And also the complementarity principle was a very important issue, and also the, shall we say, the issues that were transferred from the Rome Conference to a later stage, for example, elements of crime. So these were issues that I had on my mind all the time. But for me, the most important lesson I draw is that you have to have an efficient secretariat to support those who are really in charge, because they are the ones who make the decision at the end of the day, not the Secretariat. So those would be my lessons, and in as short as possible answer to your question.
Okay. Thank you, Hans. Philippe Kirsch, you were the chair of the Committee of the Whole, so you were really at the coalface. You were visibly the director of the conference from almost the beginning until the final minutes or the final session on the 17th, and you've now had 20 years to reflect on it. You also served as a judge at the International Criminal Court, and you were its first president. What do you take away after almost a quarter of a century from that momentous period of 5 weeks?
Well, first of all, I would pick on something that both you and Hans have said, that is that I don't think any two people lived the Rome Conference the same way, because there were very different positions, because there were major institutional different perspectives, the UN Secretariat, Hans described, the NGOs, the states, but also the Bureau, which is not exactly the same thing as representing the states, defending states' positions. But also because the conference was enormous. There were thousands of people there, and there was a text which contained something like 1,400 square brackets, represents so many points of disagreement, which meant that it was impossible to use a text like that as a basis for negotiation. So it was all difficult. There was a lot of pressure because I think states realized that if the Rome Conference did not finish its work, a second session would be a disaster, either because it would not take place or because it would get the minimum, such a useless court. that it was not worth having a session. Now, there were a number of issues that were very controversial at the time that I don't think have left a continuing legacy because they don't affect the court as it functions now, but I will flag three, which I think do. The first one is jurisdiction. Apart from the principle of complementarity that Hans mentioned, nothing else was agreed upon. There were painstaking negotiations on crimes which were ultimately successful, but there were 3 points of disagreement which were resolved through a package because there were virtually no negotiations taking place. One was the role of the prosecutor, whether he should be independent or supervised. The second was the role of the Security Council, how much control it should have or should not have. And the third one, which was the most difficult, was what states should give consent to the court before it could exercise jurisdiction. And it is on that issue that the consensus at the Rome Conference broke down, because it was at the opposite end of the spectrum. There was a strong call for universal jurisdiction defended by most states. At the other end of the spectrum, there was the requirement that both the state of the nationality of the accused and the state of the territory of the crime would have to give their consent, which was the position of the United States until the last minute. And so we thought, the Bureau thought, that you could not choose between those positions. You had to have something in between, because if you go to the most progressive, as it were, solution, you would have a very beautiful court on paper, but you would lose so much support among states that could provide financial and political support that it would not function. If you went, say, to the United States option, which was territory plus nationality of accused consent, then you would have a court that could almost do nothing. And that's why you have a system in between. You have a prosecutor who is independent but has to be approved by a pretrial chamber, and you have a Security Council which can proceed with deferrals and referrals, but has no complete control either. My second point is the functioning of the court. It is an extraordinarily complicated statute, infinitely more than any other statute of any other international tribunal. And why was that? The first reason was that there were completely new elements. One that was mentioned was victims' participation. And the second was the creation of the pretrial chamber, which was necessary because of the need to move from selection of a situation to selection of cases within that situation. And there was no experience with that kind of body, which therefore had to be developed and explained. But the second reason, which I think was more fundamental, is that states did not trust that court. It was the first court ever that had prospective jurisdiction, that would not deal with things that had already happened, where the context, the environment was already defined. So states wanted to compensate this lack of predictability in exercise of jurisdiction of the court with high predictability on the way it would behave. And so they tried, in all honesty, but in a vacuum, to detail to the most refined points what the court should do. And I will be very interested in hearing those who are involved in the court now to see whether that level of detail was positive, was a hindrance, or a combination of both. And my last point, which is will be very short, is something that both Fatou this morning and Hans mentioned, the question of cooperation. That was not so much a matter of difficulty in negotiation, but because the court was created by treaty, it is the only tribunal, it is a tribunal that could not count on any institutional support. No state support institutionally, no Security Council, no NATO, as was the case for the Yugoslav tribunal. So the whole system was based on cooperation. And cooperation, as we know, can be very uneven, even if on paper it is obligatory. And so on that too, I think the panel will address the question of state involvement or not involvement, and I will stop here. Thank you.
Just before we leave you, can I ask you about an issue that was a source of considerable controversy at the conference, which was the presence of the crime of aggression in the statute. And I remember there was a famous session that you called on a Sunday afternoon where you floated the idea that if progress could not be made on the crime of aggression, that maybe we just have to drop it. That there had been sufficient progress made on genocide, of course, which was already agreed to be one of the crimes within the jurisdiction. That was not controversial. The definitions of war crimes and crimes against humanity were still being thrashed out. But aggression was an issue of maybe we're not going to be able to do it. And that's my recollection of it. I might be wrong about this. But finally, of course, it was put in a tentative manner, saying that it was to be subsequently defined and so on. And then that process took 10 years. We only really completed the process about 2 months ago with the entry into force of the resolution of the Assembly of States Parties. It seemed like a huge amount of attention for what today is a rather modest result. And do you think that was misjudged, the importance of aggression in the statute?
Well, I think it was very clear to us that there would be no agreement on either the definition of aggression or the conditions on which the court could exercise jurisdiction. But we made a major psychological mistake in saying, okay, fine, you can't agree, now you have 3 days to agree on something or it will be postponed to another date. The issue was so sensitive that did not fly. And as you said, aggression was included in the statute, but the exercise of jurisdiction over that crime was postponed until those issues could be resolved. Currently, of course, there's no case of aggression before the court, so it's moot in that sense. But on the rest and on what happened and on how important it was, I think I'll defer to Christian Venaveza, who is in a much better position than I am to deal with that, having chaired the Kampala review conference.
You've had also time to reflect on this. You were involved in all of the issues as the head of the coalition. As the coordinator, I think was the term, of the Coalition for the International Criminal Court. And what are your insights 2 decades after that conference?
Well, thank you very much. And I also want to first thank the Academy. I am enormously impressed with what this institution has been able to achieve in the few years, and to its advisory board, and to the extraordinary cooperation between the Nuremberg city, the province, and the national government. Rarely do we see this type of effort, and I'm very pleased. I guess I am speaking here. I've been greatly honored to be the convener of the Coalition for the International Criminal Court for all these years since 1995. We presently have over 2,500 non-governmental organizations in 150 countries that participate with the Coalition. Some of my comments today will consist of reflecting the principles and policies of the Coalition. Some will be personal. And I can't help, when I look at the optics here and the optics on the front of the program, to reiterate the huge change that has occurred in these last 25 years, that I can assure you the gender participation in the 25th anniversary, the 30th, the 35th, and the 40th anniversary is going to be fundamentally different than it has been from this first 20 years, and I think that's a great improvement and achievement. The 1995 draft statute from the Law Commission was an extremely weak statute, opt-in every way possible, 20 or so different treaties. You could opt in on each one at a time. It was an unworkable proposal, but it did set the framework for what became a historic discussion. Against all expectation, that year and the year before, the Security Council had established 2 tribunals on the former Yugoslavia and Rwanda that were extremely selective. They were selective in time, in place, and in situation. The General Assembly then, and especially the 6th Committee, took this issue up, and with the goal of seeing could they create a permanent international criminal court, one that wasn't selective, but that was independent, and which would not be retroactive, but would have prospective jurisdiction for crimes occurring after 1 July 2002. The statistics that I think are relevant to this are for the coalition. We had 30 members in 1995. We had 46 at the first PrepCom. We had 300 participating by the 5th PrepCom, 800 by the Times of Rome, and we had 500 plus NGOs during those 5 weeks in Rome from more than 236 accredited NGOs. We interacted primarily with the like-minded group of countries for that 3.5-year process. It began in '95 with about 20 countries, and then came to Rome with, I think, officially about 60 governments participating, and I think it was limited because of the German mission. The largest table that any mission had in New York could only seat 60. So I think there were more than 60 that were subscribing to the like-minded group of countries. As you know, their vote on the last night was significant. India's effort to do nuclear weapons and really to try and scuttle the treaty was 114 voted to delay action. 16 were against, and there were 20 abstentions. The United States proposal to undermine the jurisdiction was 113 were for no action, 17 voted to take action, and 25 abstained. And then the vote to accept the treaty was 120 yes, 7 no, and 21 abstentions. This was, as the Times of India described, international lawmaking of historic proportions. The role in which the coalition participated in the preparatory processes and in Rome and in the post-Rome ratification and preparatory commission processes, I think was unprecedented in the development of international law and has been acknowledged from Secretary Generals, from those who supported the statute to those who criticized the statute, and we're greatly honored that the Assembly and the Court have continued this close relationship for all these years. Seamus Heaney gave us use of one of his poems. History says, don't hope on this side of the grave, but then once in a lifetime, the long, far tidal wave of justice can rise up, and hope and history rhyme. And so I think it's really very clear that what happened in Rome and what happened in that period between 1989 and 2000 was a golden moment in history. And it unfortunately would not be repeatable today. If I look at the pillars of the Rome Statute that would have no chance in an intergovernmental negotiation today, they would include no death penalty, no reservation, no immunity for automatic jurisdiction, independent prosecutor in propria motu, independent judges, victims' rights and reparations, jurisdiction in non-international, that is internal armed conflict situations, the veto restraint on the requirement veto restraint requirement on the Security Council's power to defer a situation. So I think as we do this important meeting, we need to see how we can move forward, realizing that what we had hoped was the beginning of a process that would continue has actually not developed that way, and we are in a time of great pushback. The question that Bill Chavez and the Academy asked us to consider also was what do we regret? What were the omissions or missed opportunities? And I have a few I wanted to list. Jurisdictionally, I think that the idea that drug trafficking, terrorism, and aggression didn't get in is understandable for anyone who reads how the General Assembly governments decided to do it. And as you know, several weeks ago, the crime of aggression jurisdiction has taken force. I think for NGOs, our hope also had been that that the custodial state and the state, the nationality of the victims might have had jurisdiction. But nevertheless, I think what was achieved in the Rome Statute was extraordinary. Almost all of my regrets relate to the Assembly of State Parties. I think it was a very big mistake for them to massively reduce the time they were spending on oversight, monitoring, and trying to help establish fully the new Rome Statute system. We went from never spending more than 4 weeks to 8 weeks a year in formal General Assembly processes. From 1995 to 2002, went down to 4 days. It's now up to 6, 7, or 8 days, I think. So I think that I would hope could be reviewed. I think they should have established an advisory committee on judicial nominations immediately, and that it took 10 years was unfortunate. I especially think it was a very serious omission not to have an advisory mechanism on the selection of the prosecutor. And here we are 16 years out, and there still is not one. And this is, I met with Fatou in May, and she knows this has nothing to do at all, but I think it's a terrible dereliction of responsibility not to have it in place, a proper way in which you are assessing the candidates for prosecutor, or deputy prosecutor for that matter, and trying to put forward the most qualified and effective candidates. I think the court and the assembly made a big mistake in not moving quickly to establish regional liaison offices all over the world, or at least in the 5 regions. I think it could easily have been achieved politically in the first years, and it would be now increasingly difficult, and when one doesn't know when it might occur in Africa, where 3/4 of the conflicts where these crimes are occurring are happening. I think the assembly needed to have much more structural reinforcement on how to deal with cooperation and non-cooperation and arrests. This court cannot function without arrests, and that's primarily the responsibility of the governments. I think an increasingly evident error was that the assembly stopped in 2002, and it had no option but in September 2002 to import the entire UN system into the court. But it should have immediately begun a process of deciding what parts of this common system work for this independent international judicial organization and what parts are not helpful to it. And increasingly in the last year or two, governments especially, but even other NGO members have thought, well, is this ILO tribunal system something that is really working for this small international organization, or is there something that we can do? Is the OPCW's requirement that on term limits, et cetera, something that could apply? So thus, I'm saying I think the Assembly should have had a much more robust Secretariat for itself. The director of the Secretariat, Renan, mentioned last year to us that the OPCW, from its beginning, has had an office on universal ratification. Here we are 16 years out, we have no office in the Assembly promoting universal ratification. And that, to me, is a no-brainer for something that should be done. I think it was clear that the List A, List B should have been something that had a built-in review process after 10 or 15 years. And going forward, you might see that you want to have candidates that have both List A and List B qualifications to move forward. I think the Assembly should at some point take a look at the referral situation and how the Assembly itself feels that the court, if the Security Council refers a matter and then doesn't support that referral, what are the options? And should not the United Nations, when there is a referral to this other international organization to maintain peace and security, not have to provide the kind of financial and other support necessary? I'm finishing. The very last one is that is again to mention that that the Assembly, I think, has also done. I mean, it's an extraordinary 123 governments. It's the small and middle power democracies, and I think the challenges that multilateralism is facing, and some of the opponents have couched their objection to the ICC along with other multilateral institutions, and it is going to be the like-minded group, the 100 or so small and middle power democracies and emerging democracies working with civil society from the South and the North going forward, that I think are the hope for completing this historic mission. So thank you.
Thank you. You talk about issues of the Assembly of States Parties, but of course Article 112, which governs the Assembly of States Parties, I would think is broad enough. You wouldn't need to amend the statute in order to make the Assembly of States Parties play a more dynamic role. And since we're focused here on the making of the statute, you know, one of the issues is looking at things in the statute or things that aren't in the statute that would have made a difference. So there appears to be a slight difference of opinion between yourself and Philippe Kirsch about the issue of the jurisdiction of the court. So we have Article 12, which establishes the underlying principle that the court exercises jurisdiction either over the territory of a state party or over nationals. And of course there are some exceptions to that, but that's the basic rule. And Philippe Kirsch said that a majority of states clearly would have supported a broader basis of jurisdiction, which was universal jurisdiction, but that the Bureau thought that that wasn't possible, that wouldn't work, and that we would have lost the vote for the statute on the night of the 17th of July. There may also be a question, and I'd be curious to hear all of your reflections on this, as to whether ultimately that was a wise decision, not just because it was a compromise that was necessary for the package to work, but also that it was actually something that provided an incentive to states to join the court. Because if a court which would have universal jurisdiction wouldn't really have made any difference to a state whether it was in or out then, they'd be subject to the same legal regime, whereas if they wanted to give jurisdiction over their territory and over their nationals, they had to, the only way they could secure that was to be in. It didn't look that way, my recollection at any rate, it didn't look that way on the 17th of July, but I wonder finally if that was closer to what happened. Do you have any thoughts on that? Anyone want to take that on? Philippe?
What you're saying about this package being an incentive to states to join is really another way of saying what I said earlier. Universal jurisdiction, or what Bill referred to, which was to add the custodial state and the state of the nationality of victims, which was called the Korean proposal, was seen by just about everyone as being so close to universal jurisdiction that it would have amounted to the same thing. And we thought that if we did that, then yes, it would have been a court that would be beautiful and would not work for lack of support.
I think, and again, this is where I'm speaking more individually, there was a genius in the state parties or the governments in Rome making the decision in that 95 to 98 period that they would limit the jurisdiction of the court to treaties that had already near universal ratification and not try to make new law. And there wasn't clear definitions on aggression or on drug trafficking or on terrorism that could be adjudicable, And so to limit it to war crimes, crimes against humanity, and genocide, and Geneva Conventions and protocols, I think, was a wise first move. Secondly, on the universal jurisdiction, if states agree to create an international institution that is to support something that they don't support in their national laws, you are setting up a conflict that will come back to probably wreck your ability to achieve. And so, to me, we need to work much more to get universal jurisdiction in national legislation, in national law systems, before you would apply it and ask the court to implement that.
What about the things that were left out in the definitions of the crimes? I'm thinking of chemical weapons, which has proven to be not an entirely irrelevant issue in modern times, and yet there's no explicit reference to chemical weapons in Article 8. Was it a mistake? It wasn't as if the issue didn't arise. Was it a mistake to leave it out, Philippe?
In substance, the lack of reference to chemical weapons in the statute is, in substantive law, the point I regret the most. But then we go back to the same issue. The lack of reference to chemical weapons was largely due to the fact that a lot of states, no, not a lot, a number of states were pushing for introduction of nuclear weapons, on which the legal situation was a lot less clear. And so states that found the situation unclear, of course, did not want a prohibition. And you've got the whole NATO set of countries which have nuclear weapons as a possibility, prepared to go against the court on that ground. Then some states of the developing world said, okay, fine, you don't want to prohibit nuclear weapons, okay, but then you don't prohibit chemical weapons either, because they are the nuclear weapons of the poor. That was explicitly said. And so again, when you're on a bureau, you're not at all in the same position as states pushing positions or NGOs pushing positions. You try to see what can be done without damaging a document or an institution permanently.
I turn to you as a legal advisor for the Secretariat of the United Nations. Had concerns relating to that position and relating to the status of the United Nations and its relationship with the International Criminal Court. Can you tell us a bit what were your concerns about the outcome of the Rome Conference?
Thank you. Well, certainly I was very concerned for the simple reason that if we had failed, it would have been a catastrophe. We had been waiting for 40 years after the resolution was adopted by the General Assembly asking the UN to consider the establishment of an international criminal court. And this was a unique monument in the history of the organization. We had the decade of international law in the United Nations between 1990 and 1999. And here we had developed a program in the Office of Legal Affairs. And of course, this became a very prominent element in the efforts by the United Nations. And we were following and supporting the Sixth Committee and the preparatory work before the Rome Statute. And also, we had this extraordinary, shall we say, mobilization on the part of the non-governmental organizations that could contribute to the efforts in Rome. So if we had failed in Rome, we would have caused a standstill in the question of establishing an international criminal court, and it could have taken years before we could start this process again. And I think that it's important to remember what Ben Ferrens said here about we must create, I think he said, we must create a humane and peaceful world. And as I said before, I was rather suspicious about international criminal courts, but I completely changed my mind as a war crimes rapporteur in the former Yugoslavia. And then I have combined this with the globalization of the world. And I think it's absolutely necessary to have a functioning international criminal court, because otherwise we will not be able to properly govern the world. And I've drawn the parallel with a national state. Imagine that in a country, all of a sudden in a county or a region of that country, the criminal law wouldn't apply. Could you administer that country? Of course you couldn't. And the same thing we will see in the world. We will not be able to administer the world if we don't have a proper legal system and at that a proper criminal justice system. So for me, this has become an element that is necessary if we are to create this humane and peaceful world that Ben Ferrens was making reference to. So I really would like to stress this, that I was very concerned, and at that, if we had failed, they want to have a scapegoat for the failure, and that scapegoat would have been the Secretariat.
Let me pursue that with you, because the idea that we needed to get a result, that a failure would have been disastrous, might encourage people at the conference to think that it would be all right to make some compromises and to water down the statute because it would be better to have a weak statute than nothing at all. Others, I think, the like-minded, the NGOs would say we either get a good statute or it's not worth the effort. Where do you come in on that?
Well, all negotiations have their, shall we say, atmosphere and their processes. And I think that the outcome in Rome was very successful. Certainly one could have argued about elements in this charter, but that in the statute, but this can be developed. The main thing is to get the organ operational and that it functions. Then there are several elements, but I come back to them later, which I would have done differently if I had, shall we say, had a say in the negotiations, but that's something different.
Please go ahead with that.
Well, I mean, let me just say one thing, and this I base on my own bringing up in the Swedish judiciary. Courtroom experience should be a must among the judges. You should abolish List B. I have no problem with the first round of judges. I think it was good that some of these judges had experience from the negotiations and the work in Rome. But from now on, the court is there, and then you should not allow judges with no courtroom experience to sit on the court. And also, a criminal justice system, the judges must not be too senior. And we made an examination also with our colleague here from Chile to look at this in countries when are judges normally retiring in countries. And we came to the conclusion that the large majority, they had a retirement age of 70. And this is why we have proposed that you should not appoint judges who will pass the age of 70 during their tenure. Because criminal justice, the justices have to be razor sharp, they have to be alert all the time, and they have to hear and see and understand. And since I'm now getting towards 80, I know that you lose this ability. And I would not feel comfortable sitting in a criminal court listening to people when I don't hear every spelling in this room. And also, I think that it's important in another aspect. The justice must not be too academic. I mean, judgments have to be delivered quickly. And this was my experience. Even the cases I dealt with were not of this nature, but still, you have to be expeditious here. And you can't spend months and months and months sitting drafting judgments with footnotes in the hundreds.
Hans, how would you fix the statute in order to
Well,
do that?
you don't need to fix the statute. You can just abolish this B and see to it that to appoint judges with courtroom experience who will not pass 70 during their tenure. And then the responsibility of the Assembly of States Parties. They have to realize their responsibility for the court, and in particular, they have to see to it that the court has proper funding. And the disgrace when the Security Council asks the prosecutor to look at the situation, and then they say that it's states parties that should finance that, I think that is a disgrace. That should be funded with the assistance of the United Nations. And also, I come to the Security Council, and those who are familiar with my writings, if you are not, you're welcome to Google my name and you will find my webpage. I'm very critical of the Security Council, as was Kofi Annan. And I mean, if the Council doesn't bow to the law, which organ in the world should not be the first to bow to the law that they are actually set to supervise in a sense? If the Council then asks the prosecutor to look at the situation and the evidence leads the prosecutor to the head of states or something, the Council should follow suit and order the country to deliver this person to the court. And this means also that when the Security Council applies Article 13b, where the Council asks the prosecutor to look at the situation, they should do this with consequence. Use the same yardstick. Why in this country and not in another country? And also, I would say that the Security Council, if I take Sudan and Libya, for example, here we have examples of cases where the Council should have followed suit and supported the court and the prosecutor. And then I have a couple of more observations. First of all, the Kenyan cases. Here, I was taught something when I was a young judge. If you indict someone for very grave crimes, by definition, you arrest that person and put him in detention or remand. Otherwise, the person will avoid justice and start meddling with the evidence. This is precisely what happened in the Kenyan cases. And I followed them very closely because I assisted Kofi Annan for 6 years when we worked to establish the situation in the country after the election in 2007, the Kenya National Dialogue and Reconciliation. And finally, the principle of complementarity. I was in charge of transferring the Lockheed suspects out of Libya to the Netherlands for the trial before the Scottish court. And when I heard that the ICC had sent back the Libyan cases under the complementarity principle, my question is, how can you, judges, imagine in a country that has been under a dictatorship for 40 years, when you indict relatives of the former dictator, that you could find one single judge in that country who could objectively, impartially, independently adjudicate a case against them? That was a situation, in my view, that should have been kept within the ICC. These were some reflections.
Well, you mentioned, and we haven't talked about it yet, the role of the Security Council in the Rome Statute. This is something that could obviously have been changed and could have been negotiated differently than it was. James Crawford, I mentioned James Crawford in the draft of the International Law Commission, which was a design of an international criminal court that was essentially a permanent version of the ad hoc tribunals for the former Yugoslavia and Rwanda that would be directly subordinate to the Security Council. And instead, what emerged after this lengthy process, and it's one of the fascinating aspects of it, was a much diluted version of the International Law Commission draft in terms of the role and importance given to the UN Security Council. Hans Corell, you've mentioned 13b and said the Security Council should approach it in a principled way. But I think this is like asking a gangster to be honest and not pick your pocket and steal your car. The Security Council is what it is, and it's a political body. And once you put 13b into the statute, or the other article, Article 16, which allows the Security Council to intervene in prosecutions, you've created a recipe for political interference. And others have criticized it. There were certainly, I think if we'd done a poll at the Rome Conference, Bill, you'll correct me if I'm wrong on this, but if we'd gone around and canvassed states, would they have preferred to have no role at all for the UN Security Council in the Rome Statute? You probably would have got a majority. But it had to be in, and this was the political judgment, that it had to be in because we couldn't break entirely. It was a process of breaking it. And maybe along the way, maybe it was when the British finally said we can agree with that compromise on Article 16, that they put the brakes on a runaway train that was ultimately going to end to the demise, not the demise of the Security Council, but the total separation of the ICC and the Security Council. But it's not what we got. So who wants?
Let me...
But may I say that here I saw a rationality, because the Council set up the Yugoslav and the Rwanda tribunals. They can do that again, but why setting up courts all the time when there is a court who can hit the ground running? So I thought 13b was a very good solution. But my point I want to make here is the following. In a state under the rule of law, also political organs have to bow to the law. And I've constantly maintained this. And since we are in Germany, could I tell you that I got an idea from former Chancellor Helmut Schmidt in a meeting of former heads of states and government in Hamburg. And when I was there as an advisor and started talking about the rule of law, Helmut Schmidt softly asked, I wonder if politicians understand their role in the rule of law. And that gave me the idea that elaborated between the Wallenberg Institute in Sweden and the Hague Institute for Internationalization of Law, the guide for politicians on the rule of law. And that guide is now available on the web in 25 languages, free of charge, doesn't cost anything. So please Google Rule of Law, a guide for politicians, and you will find it immediately. Thank you.
Okay. This was one of the issues that there was some dissension between NGOs on. My NGO took very few positions because our main task was coordination, but and also we didn't have expertise. But we did believe that if the state parties, or at that time, if the governments establishing this new independent international criminal court didn't define the relationship between their statute and court and the Security Council, then the Council and the P5 would determine the relationship. And if you look at what happened between March and July 15th or 16th in 2002, it completely confirms that occurred, that Mr. Bolton started waging this war to try and suppress the court, kill the baby in the cradle, I think he called it, during those months. And one of the efforts was to get an illegal Article 16 in the Security Council, which he secured, or which the U.S. secured. But the early drafts didn't refer to Article 16. The early drafts were to completely subordinate the court and the statute to Chapter 7 authority by the U.S. That was their intention to do. And that would have started this off with a constitutional crisis that would have been extremely dangerous and debilitating. But the UK did convince the US to do their Article 16 within the framework of the statute. And of course, they got it approved the second year, and then the third year, after the Abu Ghraib torture scandal, they couldn't even have support to reintroduce it. So the idea of deferring the matter, but having to positively make that decision every year is a restriction on the veto that is very little understood by people, but it was one of the strengths, I think, of this treaty.
I think this is very important, and I see Article 16 as a protection of the prosecutor, because the prosecutor has to follow the evidence and go forward. Now, if the Council comes to the conclusion that this might cause problems for peace and security, then they can make a decision, and the prosecutor can stand there head high. I did my duty, they did their duty, and let's see when we can start the trial. So I think it's very important too.
They can stop the judges too, not just the prosecutor.
You know, we are at the point in our session this morning where we're at the point in our session where we're to open this up for questions and comments from the audience. I know there are many people who were at the conference. Maybe some of you will even tell us something we don't know about the conference that you can tell us. I know that Christian Veneweser has already been called upon. There are several people, despite what Hans Corell said, there are several people over the age of 70 with very sharp minds out there. I hope you'll join in too. Christian, would you like the floor first?
Thanks. Thanks so much, and it's really great to listen to all of you. Well, I want to say something on aggression because Philippe, in a way, asked me to. I think what he did in Rome was the only thing that he could do. I think you found absolutely the right solution. What we noticed, of course, when we then negotiated the provisions is that what you didn't do, and you didn't have time to do, is to think about what actually happens to the rest of the statute when we put that in, and we had a really hard time. We had a really hard time with that, but I think the decision in Rome was absolutely the right decision. You know, on the rest of the statute, I think the first thing to say is that it's a very good treaty. And Bill has been saying for 10 years we wouldn't be able to get it today. He has never been more right than today. Today we wouldn't even get to the moment to negotiate this treaty. And if you look at it overall, I think it's of a very high quality. The things that I find problematic are the amendment procedures are horrible and make the treaty almost unamendable. And now we have a lot of states that say we don't want any amendments because it's going to lead to fragmentation, which honestly I find a bit of a dishonest argument. But the amendment procedures are horrible. And they're problematic, and of course we cannot change them because the amendment procedures are horrible. But I think that's a real problem in this treaty. The other is that we have this big regime on cooperation. So it's very clear what you have to do as a state, your obligation. It's totally unclear what happens if you don't. That's not in the treaty, and we have not been able to address this afterwards. And that is, in my view, a big weakness of this treaty as well. On other things that have been mentioned, the role of the ASP. The ASP can play with the existing provisions a role that is very different to the role it has chosen to play. I think it's disappointing that the ASP is a management and oversight body and nothing else, because the court needs something else, and the court does not get political support from the ASP. Be it on non-cooperation, be it on whatever. So I don't think that's per se a problem in the Rome Statute, but it's a problem in the practical daily reality. On jurisdiction, back then, and I think pretty late, and I don't actually remember, but Philippe does. We had the list. Territoriality, nationality, custodial state, victim state, and then you had to delete 2. Had we had one more of those, of course we would be looking, if you had like victim state, for example, I think we would be looking at a very different scope of jurisdiction today, which would be nice, but I guess that's it. A question perhaps, because we've been talking about this so much, did anyone talk about 98 versus 27 at that time? Because that's a discussion that is still haunting us in a way. Thank you.
Anna Robesamy? Behind you, for you.
Thank you, Bill, also for setting an example of a moderator who asks all the tough questions. And thank you for the shout out to Hans-Peter and the others who are not with us. Hans-Peter was as instrumental to the building of this institution as he was to the building of the ICC, and we miss you very much, Hans-Peter. In the current pushback against multilateralism, it's fortifying for us to hold on to our memories of Rome, and this panel has been fantastic. Thank you so for coming. all of us who were there, we knew that moment, didn't we, Fabrizio? We were living history, and nobody will ever forget that final night, which came at the end of an increasingly bitter fight. Astonishing to many of the very young people, I was one of them at that time, who came there as pure idealists, or at least halfway pure idealists. And Fabrizio, actually, who's sitting right in front of me, came to symbolize those final weeks. It was 5 weeks for those who have forgotten. 5 weeks of mostly no sleep. And when under Philippe's leadership, it got through, you broke down crying, and you thus gave us all permission to break down crying. Showing us the relief and the enormity of what we had just witnessed. I was wondering, what do you think was crucial in Rome that hasn't gotten nearly enough attention? That should be written about more, perhaps looked at from the angle of highlighting and lifting up the power of multilateralism. I was thinking along the lines of what Christian had just laid out, who clearly knows, but perhaps there are some other issues that you would like to see discussed more vigorously.
Okay, pass it up the next row to Erica, I think. No?
Thank you. Ladies and gentlemen on the panel, thank you so much. And references to the Security Council will definitely come up tomorrow again in the panel on engagement and disengagement, so I will not comment on that now. What I actually do want to comment on, and it's a question to all the panel members, is the assumption that seems to be present in the room that the statute would necessarily be better if we had more crimes. The fact is that the court can hardly function with the crimes that it has. And I say that with respect, but I also say that as somebody who actually is one of the few in the room who lives on the African continent for the largest part of the year, where we have a very hard struggle in keeping the court alive. And I will not elaborate on that now. I will ruffle all the feathers on that point tomorrow. But isn't there something to say for being a bit more modest and less ambitious and do less but do it well? Put somebody away not for like 27 crimes that takes you years to, get into the warrant and then not being able to actually get the guy put away. Put him away for 1 or 2 things that are well argued and make sure that he's gone. Make what we have work, instead of also creating totally unrealistic expectations within civil society with wanting, please, we don't want a Malabo protocol. That thing in Africa which is now supposed to replace the ICC, which it simply isn't workable. Isn't it time to take a step back and say less can be more, and it's time for everybody to be a bit more modest about what should be in the statute and make work to make that work. Thank you.
Thank you. Pass it behind you to Monsieur Keita.
Thank you. Xavier Jean Keita. I'm the principal counsel of Defense Office in ICC, an independent office created by judges, ICC judges. Thank you for that. I want to thank the panel because it was very, very interesting. I was not among those who were making the sausage, but we were several observing and expecting. While I can understand that maybe the list B should be taken off and to have judges with experience, I respectfully disagree with the proposal that suspect and accused should be detained to secure the evidence. I think that the principal detention should be an exception and liberty the rule. And I think that when we start a case, we have to secure evidence and to fight to protect this evidence. I was 1 week ago in Côte d'Ivoire and of course defending hardly the court because we are often attacked as a colonial court. This was easy to combat. But there was some legitimate question about how ICC can be stopped by states not being part of the Rome Statute, meaning not being state party. And you were talking about Article 13b, and which is to avoid a gap when a state cannot take the initiative or the prosecutor cannot take an initiative. We have to rethink about this referral by the UN Security Council, who is supposed to be in charge of peace and security. The real problem is not the Rome Statute for me. The real problem is the veto. How is it possible to have one of the five to let some crimes still happen in Syria while and destroying the main and the ideal role of the court because of a political reason? My question that those states or head of states will one day, and I hope that, accountable of their position. This is how we can ruin the credibility of the court vis-à-vis some states complaining about or combating the court. My proposal should be that to avoid a veto, possible veto, we should give a role to the Assembly of the UN and not to let Russia or United States or any of the five stop because we fail ensuring the security and the peace in the world. Thank you.
Thank you. It's an interesting theory, and of course it might involve some conflicts with the Charter of the United Nations were we to do that. But ultimately it would amount to saying that we should amend Article 12 and give universal jurisdiction to the court. That would solve the Syria problem. I'm not sure it would bring any suspects any closer to The Hague, though, if we were to do that. Are there other comments? Yes, in the back row there, please.
Thank you. I'm Juan Botero, professor at Pontificia Universidad Javeriana in Colombia. This question may be more for Ambassador Correll. I know there's a panel on state engagement tomorrow, but the issue in Rome on incorporation at the national level, I wonder if you can give us some guidance there. I mean, Germans have adopted international criminal code incorporating, but my country, Colombia, has not. So arguably, when push comes to shove, the internal force is severely weakened. So I wonder if you have guidance on that point. Thank you.
Okay. Anyone else? Yes, please.
Okay, my name is Dan Zhu, coming from Fudan University in China, and I would first like to thank the panel for their wonderful contribution on the negotiation of the Rome Statute. And as the panelists mentioned the Article 13, paragraph B, and Article 16, which deals with the relationship between the Security Council and the ICC. And actually, in the past, the Security Council has acted under these two articles and passed several resolutions. But these resolutions arguably are not in strict compliance with these articles, especially the one on the Darfur and on Libya. The Security Council has intentionally excluded nationals of non-party states from the jurisdiction of the court. So I just wonder, during the negotiation process, whether the drafters has envisaged a mechanism for the court to judicially review the Security Council's resolution about their legality. Yeah.
Do you want to take that question up? That's about the whether it was considered a mechanism to review the legality of the Security Council referral.
Well, I think this is when the Council passes a resolution referring the matter to the ICC, asking the ICC to assist them in maintaining peace and security, but they put in clauses in the referral that are not consistent with the Rome Statute. That then is something that I think the Assembly should have some very basic principles that it communicates to the Security Council and the UN on this matter, because it puts the prosecutor, for example, in a very difficult position of enforcing something where they are participating in a conflict of standards, etc. So it's awfully dangerous. People are not convinced that the Assembly has the integrity itself now to be doing this type of review, and yet I'm not sure who's going to protect the court when the council, and especially the veto members, are not implementing. They've asked the court to assist, but then they actually then undermine the ability of the court to do its work. How do you address that? And I believe you can only address it by having a principled state parties take decisions and then implement those decisions, because they're the same state parties that are member states of the UN. They're the same state parties that are permanent members of the Council, France and the UK, and elected members of the Council. And the way in which they have, okay, we behave over here this way, and then we get into this job and we completely behave differently and have different standards is part of the problem. But it isn't the problem of the court, but the court gets the blame.
Philippe, would that have flown at Rome?
No, certainly not. No, I have. I think what Bill says is absolutely sensible, but I have no. I don't think that the Assembly of States Parties would ever be able or willing to do anything like that. Going a little further, if I understand the question to be in part whether the Security Council could have in referral something that is inconsistent with the Rome Statute, I don't think the court is bound by that at all. No more than a court is bound by starting an investigation if the court finds that there's no basis to start an investigation. So I think political mechanisms between the Security Council and the court are too weak, and it's up to the prosecutor and the chambers to really rule on them.
I think I agree with you, and I think actually personally that the statute is quite adequate to deal with that. If the Security Council, as it's done twice, sends a resolution to the court that has deficiencies and illegal clauses, I don't see there's any reason why the prosecutor couldn't just say, I'm afraid this doesn't correspond to Article 13b, and I can't sever or correct your resolution, and so you can try again and adopt another resolution and get it right. And if you don't get it right, well then I don't have to do anything because it's not a resolution that's consistent with 13b. And if the prosecutor won't do it, I don't see why the judges at the pretrial chamber couldn't say, we're afraid that this isn't sufficient to trigger the jurisdiction of the court. Whether that will ever happen is another matter, but to say that we have a gap in the statute that makes that not possible, I don't think is correct. I think that we have everything we need in the statute to do it, and I wonder about the solution of giving it back to the ASP as if you set up another political or politicized body in a kind of competitive environment with the Security Council. I don't know if that has a future.
Well, again, I think I'm not saying to give them necessarily the power, but at least they ought to discuss some of these issues of non-cooperation, of cooperation, of how they should be proceeding and not proceeding. And say the way in which the international community, in particular NATO, implemented the Syria resolutions was so flawed and so counterproductive, and who was going to bring that up and discuss it? That shouldn't an assembly, if of course they are part of the same governments that implemented it. And I think civil society, many members of our coalition were very critical of the way the first prosecutor handled the request for referral for Libya within 3 or 4 days. And I think all of those are lessons learned, I hope, that in the future the Assembly and the organs of the court can address more effectively.
Thank you, Bill. I just wanted to add to perhaps a point of clarification to the issue of Security Council referrals and the action taken by the office in those cases. And yes, Bill, I'll take note of the way the Libya referral was handled, and I think we have learned a lot since then. But in terms of what the court can or cannot do, I think that the court surely, and the Office of the Prosecutor will always do this, will verify whether all legal requirements for a referral have been met. Meaning, so if we have subject matter jurisdiction, so if it has been referred involves crimes within jurisdiction of the court, if the requirements of territoriality, and that one was trapped by the referral, but if the requirements of admissibility are met, and if the conclusion of the office's analysis is that actually what has been referred does not involve crimes within the jurisdiction of the court, or that actually there is a meaningful national response, even if one that the Security Council may not like, then the office will not open an investigation. That part of the analysis belongs solely to the Office of the Prosecutor. And basically that is something that the office will do in every instance. Now, other aspects of the legal equation cannot be dealt with by the court. The legality of the Security Council, Chapter 7 decision under the UN Charter, that's not a matter for the court to decide. Whether the issue was properly identified as a threat to international peace and security, that belongs to the Security Council, not to the ICC. How far has the Security Council gone in imposing duties of cooperation? That's primarily a political issue. It's not an issue the ICC has to adjudicate on. Now, interestingly, we're now discussing we were just discussing in the Bashir appeal on immunity, precisely the scope of the obligations imposed by the Security Council to state parties and to non-state parties, which are not symmetrical, obviously, and that can take place within the context of the judicial proceedings, that these are issues of interpretation I'll discuss. But in terms of adjudication, the issues are going to be confined to whether crimes within the jurisdiction of the court have been communicated as part of the referral, and whether the principle of complementarity has been respected or not. And the rest belongs elsewhere.
Let me just go back to the panelists for a second and ask a question, if you can reflect again on the Rome Conference. When you went in on the 15th of June, when it began, did you have a sense of expectation that it was going to succeed, that it might succeed, or that it was doomed? And did that change over the course of the 5 weeks, so that on the evening of the 17th of July, when David Sheffer said, I call for a vote, that you were confident that the vote was going to pass? Nervous or pessimistic?
Well, I can speak for myself because I wasn't on the inside the way Ambassador Kirsch was at the time. I would think we had no idea. It was one of the most stressful. It's released around 2 in the morning. I forget how many 30 pages, take it or leave it. As President Kirsch mentioned, there were already mistakes that were corrected during the day on the materials that were released. The Article 24 was very controversial. Many of the NGOs were, especially the international human rights NGOs, were very initially against, but whereas Women's Caucus and the regional NGOs were mostly supportive of what was going to be approved, if it was approved. We understand the like-minded group was also divided during the first 2 or 3 hours and very upset over some omissions, etc. But I think by the time it was supposed to be 10, then 11, then 12, then 3, then 4, and finally it convenes at 6 or 7. I can't remember the exact time, and proceeds fairly quickly. And I have never been in an intergovernmental meeting where the outpouring of support for what they had done was as emotionally expressed as it was that evening in the Committee of the Whole for 15, 20 minutes. It was an extraordinary outburst of recognition. Oh my God, we have achieved something that we did not think possible.
When I arrived at the Rome conference, I had no idea because I was leaving other issues. I came and I really started dealing with the statute when I got there. But I thought this is a negotiation can succeed, and I was not pessimistic. On the night before the adoption of the statute, I think no one had any idea what kind of support it would get. I was comforted early in the morning because when I came into the building and a delegate who had been notoriously difficult throughout the conference came to me with a fierce look and said, "Congratulations." So I said, okay, we're safe. Thank you.
So you would have bet €1,000 with me, Eddie. Hans?
Thank you very much. Before I answer your question, I should answer Juan Botero's question about the shall we say, incorporation of the Rome Statute at the national level. That question depends on, before I do that, by the way, Juan Botero was instrumental in developing the World Justice Project's Rule of Law Index. If you're not familiar with that index, please visit World Justice Project Rule of Law Index. They have mapped more than 100 countries with more than 90% of the world population. And here you can find, even in spider diagrams, exactly how states perform in different contexts in a rule of law situation. It's very, very instructive, and I use it, and I think many should use it when you assess the rule of law situation in a country. To answer your question, it depends on whether the country is a monastic or a dualistic country. If it is a monastic country, when they ratify the treaty, basically the treaty should become the law of the land. Sorry? We have to wrap up. Yes, but I just wanted to answer the question. To wrap up, so answer the question that if you're monastic, it becomes the law of the land. If you are not a monastic, then you have to introduce the statute in your national law by national legislative acts. This is the difference. Now, to answer your question very, very quickly, I was very hesitant at the beginning, and my main concern was, would we be able to serve this 5-week conference so intense that the negotiations would be? But towards the end, I became more and more positive. So at the end, I was actually rather positive that we would have a positive result. And this was what came out. Thank you.
Well, Eduardo has asked me to conclude with some remarks and to perhaps suggest some ideas that we can take away from this discussion about the making of the Rome Statute, about the work of the sausage makers over the 5 weeks at the Rome Conference. What I get from the comments of the 3 panelists, as well as from those of the audience, is that there is no magic improvement that could have been made that would have changed the future of the court or the complexion of the institution. That we can look at things that might have been, but that it's almost impossible really for us to second guess the calculations that were made by the Bureau about the final package and the chemistry of the whole product. And we might say they could have put universal jurisdiction in, or they might have added chemical weapons, and what we don't know is whether that would have changed it so that instead of meeting somebody who was a fierce critic telling you congratulations on the morning of the 17th of July, that you would have got a sense very quickly that this was not going to fly. I was struck by the fact that there was really no discussion, I guess because we take it for granted, that the jewel of the Rome Statute package, which is the independence of the prosecutor, is nobody questions that and nobody wants to change that at all. As for the Security Council, we had lively exchanges on that subject, and it's interesting to me that the issue of the Security Council remains one where we continue to develop interpretations based on the statute. The theory when we talk about the issue of immunities, that some of the judges have embraced that there are implicit conditions in the Security Council resolution. We continue to debate that and to dispute that, and people think maybe we'll get some clarity when the appeals chamber pronounces in a few months on the Jordan case. Of course, we don't always get clarity when the appeals chamber pronounces, and I'm not personally that confident that that's going to be the result, but we shall see. I think it was Voltaire who said that the good the best is the enemy of the good. And I think that that's really the situation, that's the way to summarize our assessment 20 years after about the Rome Statute. The best is the enemy of the good. It could have been better, and we're not even sure how it could have been better. We could have perhaps removed some provisions on the qualifications of judges. We could have added things or taken them away. We have mechanisms that facilitate that, and Many of the suggestions or comments that have been made and will be made in the coming days about problems with the operation of the statute probably find their solution within the statute. And we also see that to the extent that we have a creative office of the prosecutor, we have two little words buried in the statute, which is, I think, 30 or 30,000 words long, called preliminary examination, that have taken on greater proportions than some might have thought in 1998. And we have jurisdictional provisions that seem to have made it possible for a crime that was very largely, perhaps, committed on the territory of a non-party state, for the court to appear to be able to exercise jurisdiction. So, like many legal instruments, it has the doors are open. The potential is there for us to enlarge it, depending on what the political climate can take and depending on the creativity and imagination of the judges. And so it's a good tool, and it remains one. And we're not likely, again, who was it who said it's not amendable? It was Christian, I guess, who mentioned the difficulty of amending it, not the least the fact that to amend the amending formula requires passing by the amending formula, and so this is, well, we're not going to go there. I want to ask the audience if you would thank our three panelists in the usual way.